Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I am Mark Solomon, a defense attorney in Denver, Colorado, and today's question, with the Derek Chauvin trial a month behind us, expert witnesses testified. What's an expert witness? What did they say? What goes into presenting expert testimony in trial? But before we get to that, don't forget to click like and subscribe with a little bell next to it to be notified of future videos. If you're enjoying this video, you want to see more when I put them out, click that button. Okay, let's go ahead and shift over to talk about what is an expert witness. In the United States, the Daubert standard has taken over since around 1994. 95, that's when the standard changed, and basically any testimony that is going to use specialized training, knowledge, and experience of the witness, something not in the common knowledge of the layperson. In other words, if you don't have the training, knowledge, and experience that this witness has, you probably wouldn't understand what they're talking about, or they wouldn't have the background to be able to say what they say. So, really fast, expert witnesses are allowed to present opinions. And when they present their own opinions, it's to be taken with the same weight or whatever weight the jury wants to give. But the judge decides what witnesses testify. You have what's called a Daubert hearing. That's where the defense attorney or the prosecutor, whoever is going to be presenting that witness, has to prove to the judge that this is qualified testimony. In other words, that this person isn't producing junk science or something that just isn't true. Once the judge decides what expert is able to be presented to the jury, the judge is also going to decide what this expert is going to be declared a witness in. You know, I've had trials where police officers have been declared witnesses in field sobriety tests and DUIs. I've had trials where a witness was declared to be an expert in forensic cell phone technology or forensic cell phone extraction. And when they do that, that doesn't mean they can present any opinion that they want. It means that they're limited to what they're an expert in. Okay, so there's the Daubert hearing. The judge decides who gets to testify. This is a heavily litigated part of a trial before the trial, and each side has the opportunity to present witnesses to counter the other side's witnesses if they can pass that Daubert standard. So let's go back and look at some of the witnesses who testified in the Derek Chauvin trial and what did they say. So this is the Wikipedia article on the trial. And in this case, the prosecution presented an expert witness testimony by the emergency medicine resident physician in the medical center who pronounced Floyd dead. This is the type of expert who, you know, not just anybody can testify that somebody's dead. You have to have training, knowledge, and experience. Otherwise, the witness, a lay witness, might be able to testify that they took a pulse, they didn't get any, there was no breathing, the person laid there for hours and hours and hours, didn't get up, didn't say anything, therefore, I thought he was dead. But it takes an expert to actually testify that somebody was actually deceased. And in a murder trial, that's a pretty important fact that the prosecution needs to bring out. Here we go. Martin Tobin, a pulmonologist who testified that the lack of oxygen to the brain and heart led to Floyd's death. Now, because of that, you have a medical examiner say that this person died from asphyxia. You have another pulmonary expert to say that the lack of oxygen to George Floyd's brain caused the death. Next thing that happens is a forensic medicine expert, surgeon, and former emergency room doctor testified that Floyd died from a lack of oxygen, not a fentanyl overdose. So the prosecution's bringing in all these experts to testify as to what it was and what it wasn't. What did the defense do? The defense cases brought in another expert, right? A counter expert, David Fowler, a retired forensic pathologist, said that the manner of Floyd's death should be classified as undetermined rather than a homicide. And he said, in his opinion, Mr. Floyd had a sudden cardiac arrhythmia due to his atherosclerotic and hypertensive heart disease during his restraint and subdual by the police. And in his determination, the fentanyl drugs and the methamphetamine contributed to the death, and exposure to the vehicle exhaust could have potentially contributed to causing increased carbon monoxide in his bloodstream or even carbon monoxide poisoning. However, the defense expert testifying to this didn't actually examine George Floyd, didn't actually preclude any of the possibilities. All he did was look at the reports and posit these things were possible. That's it. So he didn't actually examine the body. He didn't actually do anything to create new evidence. All he did was give a counter opinion, which is exactly what expert witnesses do. That said, when you have that type of expert who says he died from asphyxia, you have another expert saying he didn't die from fentanyl, and you have another expert saying it couldn't possibly have been anything else, and then you have a defense expert saying it might have been all these other things. It allows the jury to give weight, and what they're doing is they're balancing whose expert they believe more. And that's the role of the court, to present all of that counter evidence to the jury, and that's why this case went the way it did. Expert, counter-expert, and the jury went with the prosecution's experts. Now, is that an issue for an appeal? Good question. The answer is tricky. If the prosecution presented evidence and the defense didn't know it was going to happen, they didn't have a chance to counter it with their own experts, that's a great issue for appeal. If the defense chose not to present evidence, or if they chose not to examine the body, if they chose not to do certain things, the role of the defense attorney is given great deference in the strategy and tactics of presenting a defense. In the same way, the prosecution has the ability to present the evidence they want, to present the case they want to present, in how they think they can get a conviction. So if on appeal, the appeals courts generally don't look at that type of strategy and tactics unless it rises to the level of actual incompetence. If the defense attorney said, well, I didn't know what that expert meant, I didn't understand why it was important to the trial, and therefore I decided not to present any expert witnesses to counter it, that might be ineffective assistance of counsel, of just complete incompetence, where the defense attorney didn't know what he was doing. That's probably not the case in the Derek Chauvin trial. So that's a good question from one of our viewers. So great question. Keep them coming. But that is the question and answer for today. If you would like your own question answered in a future video, you can put it in the comments below, tag me on Twitter, or email it to me. And as always, you have a right to remain silent. If the police officers talking to you ask you the who, what, where, or anything about what you know, or anything, you have a right to remain silent. I don't want to talk to you, and I want a lawyer. Perfectly valid responses. Thank you for watching.